There are typically three scenarios when couples are looking to obtain immigration permission for one of them, who is not a European Economic Area national, also known as an EEA national, to live in the UK on the basis of their relationship. One is where the other partner is a British citizen or has permanent residence in the UK. Second is where the other partner is an EEA national. And third is where the other partner has temporary immigration permission to remain in the UK. For example, they are sponsored by a UK employer to work in the UK under Tier 2 of the points-based system. Where the couple is married or in a civil partnership, they are normally only required to provide their marriage or civil partnership certificate as evidence of their relationship when submitting the appropriate immigration application. However, we usually advise that the couple should also provide other evidence of their relationship to prove that it is genuine, such as documents which demonstrate that they are cohabiting. Where the couple are not married or civil partners, in all three scenarios, they will have to demonstrate that they have lived in a relationship akin to marriage for at least 2 years. In order to satisfy this requirement, the couple must normally have cohabited for at least 2 years and will have to provide documents demonstrating this, such as utility bills, bank statements, tenancy agreements, and so on, addressed to them jointly or individually at the same address throughout that period. One of the main issues that we come across when advising couples on their UK immigration options is in relation to the scenario where one of the partners is a British citizen or has permanent residence in the UK. In this situation, in order for the non-EEA national partner to join or remain with the British citizen or person with permanent residence in the UK, they must satisfy a set of financial requirements. At a basic level, this means that the British citizen or person with permanent residence must demonstrate that they have earned a minimum of £18,600 over the past 12 months. In addition, if they are currently in employment and they are in the UK, they must demonstrate that they will continue to be employed in the UK in a job which pays at least that level of salary. If they are currently employed overseas, they must demonstrate that they have been offered a job in the UK which attracts a salary of that level or above. If both parties are in the UK, any salary that the non-EEA national earns through legal employment in the UK can also be counted towards the £18,600 threshold. However, if the couple are overseas, it is only the British citizen's or person with permanent residence's salary and UK job prospects which can be counted for the purposes of the application. This can cause particular issues if the non-EEA national is the main breadwinner and the British citizen or person with permanent residence is not in salaried employment or does not intend to work in the UK. In this scenario, there are other ways that the financial requirements can be met. For example, if the couple can demonstrate that they have held a certain level of earnings for a set period. However, this way of meeting the financial requirements can be quite difficult to satisfy. Strangely, where a non-EEA national is applying for immigration permission to join or remain with an EEA national in the UK, there is no minimum financial requirement. In the case of a non-EEA national looking to apply for immigration permission to join or remain with a partner with temporary UK immigration permission, the financial requirements vary depending on the immigration status that the partner possesses. However, none of the financial requirements in this situation are as onerous as a situation where a non-EEA national is looking to apply for immigration permission as the partner of a British citizen or someone with permanent residence. Where a couple is separating or going through a divorce and one of the partners is a non-EEA national, and the non-EEA national wishes to remain in the UK, the non-EEA national would normally be required to apply for immigration permission to remain in the UK in their own right. There are only a few instances where the non-EEA national may be able to apply to remain in the UK on the basis of their previous relationship. These include where the partner is a British citizen or has permanent residence in the UK and the non-EEA national is a victim of domestic violence, or if the partner is an EEA national and the non-EEA national qualifies for a retained right of residence under EU law.